So we're back here at the table. If you guys remember the last discussion, there was some confusion as far as the Bruner case and it being affected by the results of the
Murphy case?
Murphy case.
Yeah.
So if you could, Jessica, like what exactly happened there?
So in the last discussion on the table, we were talking about the Murphy case, and one of the things that I had brought up was the connection with the Bruner case, and because we had reported on May 7th that the Bruner case was delayed because of the Murphy case being in the U.S. Supreme Court. We have learned, we were contacted by a viewer, and we've in turn requested court documents that confirm that's inaccurate. The Bruner case was not delayed because of the Murphy case. In fact, the Bruner case is currently in the Mvskoke Nation Supreme Court, and that's where the confusion was. So we have issued a new story clarifying that, and Sterling will go into some of the detail on what else we've done.
Yeah, as well as a retraction on the old one. So typically we like to keep these segments organic, but due to the high priority nature of this issue, I've got a script, nonetheless genuine. So court reporting is tough for many reasons, such as reporters not being allowed to bring recording equipment, and sometimes the complex nature of the proceedings and priority of the subject matter. We generally engage with our staff assigned to a hearing and ask questions to verify accuracy and inform our edits. Because of the complex elements I mentioned, our standard is to keep details to a minimum and try to get only the most essential elements of the hearing in our coverage. If there is something the reporter seems to waffle on regarding some facts, when we engage them, we will either omit details that aren't wholly relevant or seek further verification of essential facts. Due to the freelancer's credentials and experience and their certainty about the final decision during the hearing, we accepted her account as wholly accurate. On this one, our top full-time staffers were able to engage her collectively about the proceedings. We take responsibility for our fact-checking and are talking about what due diligence we might review next to the standards of turnaround in our industry, but we feel to a certain extent that we assign stories to the people most qualified to handle the material and have to trust their discretion and ability to get the most essential details correct for their assignments. Due to the high priority of this assignment and the nature of the error, we decided to terminate our contract with the author. As you know, we're in the business of accountability, or at least getting the best representation of the truth for our audience, and thus we have to hold ourselves and our people accountable as well.
So that brings us to what did we find out? So we got the tip, and then we went to the district court and tried to confirm, because in the original story, there was a quote from Judge Bigler that said, my hands are tied until the Supreme Court makes its decision. So the original reporter interpreted that to mean the United States Supreme Court, but it was actually the Mvskoke Nation Supreme Court.
And that was a big jump, and
that's what the repercussions. So, but what we did was we went to the court and we said, can we confirm, we're trying to verify this tip that we've received. Can we confirm what the intention by that statement was of the judge? And at the court they said, yes, it is the Supreme Court, and you guys need to go to the Supreme Court and see what they can tell you in relation to that, because they didn't want to speak for the Supreme Court or anything. So we went to the Supreme Court and requested all of the filings in relation to the Bruner case. So what we got is this stack of paper here, and all of these documents are available on the website if you want to go through them and read them. It's in a nutshell, what we have is when Bruner was brought in and to be charged in the district court, the AG's office, the Mvskoke Nation AG, charged him with felony counts. Bruner's lawyers challenged the classification of those felony counts and wanted them to be classified as misdemeanors. So Judge Bigler said that you guys can file this appeal or this thing with the Supreme Court to challenge the classification of these charges. So that's what they did. And then that started the whole process that is all of these legal documents of a back and forth, where eventually it ended up in the Supreme Court. And the Supreme Court's going to decide on whether the charges against Bruner can be classified as felonies or whether they have to be classified as misdemeanors. The charges in particular that they are charged with, that Bruner's charged with, is Title 21, Section 11-103 and 11-104. Okay, we went in and looked at those specific sections, and the word felony isn't in there. So the Supreme Court's going to have to make that determination at this point.
Whether they're felony charges or
Yes.
misdemeanors.
So at this point, the original charges haven't even been addressed
Yes, the
yet,
charges.
right?
He hasn't actually been charged until they can work out this
Classify.
classification.
They can't. It sounds like Supreme Court's issued a stay, so no other things can be heard in district court or otherwher until this has
Until
been
this gets
determined.
Yeah,
resolved.
well,
Okay.
and because of the filings we've seen from Ms. Free, et cetera,
Right.
all of that stuff is still going to happen in the court, but they've got to charge him first, and so that's where we're at. The last paperwork on the timetable for this is June 12th. So they're trying to expedite this process so that they can get this into court, because it's been a long time since.
Right.
When was the original?
Well, I mean,
When was he charged?
the raid happened last August 2017.
So we're nearing a year now.
So we're nearing a year since the actual raid happened, that this case has been, developing in the court system. So now we're in the Supreme Court. The Supreme Court will decide whether these charges are felonies or misdemeanors, and then is the process. Then it will go back to district court
Yeah.
and carry on.
The stay should be lifted, and then you would assume that the AG would charge him with whatever the Supreme Court says they can charge him, and then go from there. Now, in these documents, when the Supreme Court took the issue up about the classification of these charges, immediately after that was done, Bruner's attorneys filed a motion to dismiss the case, and that motion was rejected. So
Because of the stay.
just because they said we have the ability to make a determination in this situation. We can't throw it out because the original filing was incorrect. Essentially, what they were trying to do is say, you guys charged us with a felony, but it can't be
You're
classified
talking
as a
about
felony.
murder,
Yeah,
Yes.
it
Okay.
can't be classified as a felony, so you got to dismiss the charges. The Supreme Court said, no, we're going to hear it. We're going to hear whether these can be classified as felony. So you would assume that the AG's office would bring whatever classified charges against him in the court after that's over. They might have to file a new information, or who knows what we're at. But that's the objective, is for this to get heard in the district court and then move on from there. And it might get challenged up to the Supreme Court. Who knows? The argument on the other side from Bruner is that what's the difference between getting charged with a felony or I'm saying from the audience standpoint, what's the difference between getting charged with a felony or a misdemeanor in this case? Because the punishments are going to be the same, $5,000 or a year in jail. Because the Creek Nation has an agreement with the state of Oklahoma, so that the state of Oklahoma treats felony convictions from Creek Nation's courts with the same penalties that the state has. There will be additional penalties leveled against Mr. Bruner if he is convicted of a felony on the state side, like he won't be able to get a loan and other things like that that the state does on people who are convicted of felony there. So that's going to be the argument from Bruner's side, is that, you guys want to charge us with a felony even though it's not delineated in the code that it's a felony, and it's going to add additional damages to us. But, you guys, anybody who wants to can go through and read all these court filings. We're going to bring more
Well, we've still got
documents.
there's still some more filings
Yeah.
to be made. Like you said, there's going to be additional filings through at least June 12th, if not additional ones after that, before the Supreme Court can actually hear the case.
Guys, we're going to make these documents available online for the audience to check them out. Jared, we appreciate you going ahead and getting these to clear this up.
Yeah.
And going through them and breaking down what we kind of missed there. And on behalf of me, the manager, I apologize, and I'm very much appreciate you guys helping us get this straight.
Great. And any further, we're going to have another table on this in the future, I'm sure, because that once the Supreme Court has their decision and the whole thing gets transferred back to the district court, we're going to go from there, and because this is like one of the major cases at the Creek Nation right now.
Obviously, we have a long ways to go here from the looks of it, and I guess we'll table it for now.